Thank you everyone for being here today. My name is Rebecca Ho. I am president of Berkeley Federalist Society. Before I start, I would like to thank Public Law and Policy Program for co-hosting this event with us. Our speaker today is Professor Josh Blackman, who I will refer to now as Josh, of
Please,
course.
Josh is good. This is the dean, I'm Josh.
You call me Erwin, it's fine.
Professor Josh Blackman is the Centennial Chair of Constitutional Law at South Texas College of Law, Houston. He obtained his undergraduate degree from Penn State and his law degree from the Antonin Scalia School of Law at George Mason University. After graduating from law school, he clerked for Judge Kim Gibson of the United States District Court for the Western District of Pennsylvania and Judge Danny Boggs of the United States Court of Appeals for the Sixth Circuit. Professor Blackman is an expert on constitutional law and the United States Supreme Court. He's written more than 6 law review articles that have been cited nearly 1,000 times. He's a frequent guest on TV and has appeared on NBC, CBS, ABC, Fox, and the BBC. Professor Blackman is the author of 3 books, one of which is the topic of his talk today. His book, An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, was a top 5 bestseller on Amazon. Thank you for joining us today, Josh. Providing commentary for today's event is Dean Chemerinsky, who really needs no introduction, so I will not.
Perfect.
I will just say thank you for joining us today. And with that, I will turn it over to Professor Blackman.
Thank you.
Josh.
I tell my students to call me Josh. She won't do it, but I'll do the same for you. Thank you so much. It's a pleasure to be here at Berkeley. How many of you taken constitutional law already? Okay, most of you. Okay, some of you haven't. If you haven't taken Dean Chemerinsky, take his class. He assures me all the cases I'll be talking about today are on the syllabus, so you'll learn them maybe next year. I wrote a book with Professor Randy Barnett at Georgetown, 100 plus Supreme Court cases everyone should know. And we tried to pick the 100 most important, most significant, most noteworthy Supreme Court cases. I can't possibly cover all 100 in the limited time I have today, so I want to think about 5 or 6 cases. And I picked these cases not because they're new and controversial, but just the opposite. They're old, and the substance of those cases aren't really timely today. And I picked these cases to try to illustrate why things aren't always the way you think they are, right? What you might think about issues today may not have been the way people thought about those issues in the past. So the cases I want to talk about today, and you'll have these on the exam next year, will be Prigg versus Pennsylvania, Dred Scott v. Sanford, Cooper versus Aaron, the civil rights cases, Heart of Atlanta Motel, Lochner against New York, and West Coast Hotel v. Parrish. These are all very famous Supreme Court cases that you either studied or will study. So let's start with Prigg, which is a case that should be taught more than it is. As I'm sure you know, the Constitution was ratified with a number of so-called compromises. And a number of the compromises concerned the issue of slavery. Right? One of the provisions governing slavery was called the Fugitive Slave Clause. And this provision basically said if there was a person who was enslaved that traveled from one state to another, that there would be an obligation to return that person back to the state of origin. I'm summarizing the text. But the text was silent about how this provision would be enforced. Would it be enforced as a matter of what's called a comity? That's not like ha-ha comedy, comity, C-O-M-I-T-Y, that is relationship between states? Or was this something that gave Congress an enumerated power to enforce? Shortly after the Constitution was ratified, Congress enacted what's called the Fugitive Slave Act. This act authorizes so-called slave catchers to travel between states and retrieve so-called runaway slaves. Now I say so-called because there wasn't much due process going on. Very often people were falsely accused. People were not the one they were looking for, were hauled back downriver in any event. It was a dreadful law. But was it constitutional? We often associate the cause of slavery with the issue of what was called states' rights. That is, the southern states favored states' rights and they opposed the strong central government. And even today, conservatives are often associated with the cause of states' rights. But what we saw with Prigg was just the opposite. It was the southern states, it was the slave states that favored a robust federal power to enforce the Runaway Slave Act. And it was the northern states, the abolitionist states like Pennsylvania, that tried to resist this federal power over slavery. Let's talk about Pennsylvania for a minute. Pennsylvania enacts what were called the personal liberty laws. The liberty laws provide some process to people accused of being runaway slaves, that a local judge had to certify that this was in fact the person who was to be returned down south. And then we have Prigg. Who is Prigg? Prigg was a so-called slave catcher who targeted a person who had left Maryland with the consent of her owner. Her name was Margaret. The Pennsylvania courts actually charged the slave catcher with kidnapping, which is really what it is, bringing a person against their will. All right. Prigg says, no, your state conviction for kidnapping is void because of the supremacy clause, because the federal law gives me the authority to return the slave. The case goes to the Supreme Court. Unanimous decision upholding the Slave Act. Justice Joseph Story, who you may have heard of his Story commentaries, wrote an opinion that said, yes, Congress has this power. And Story endorsed a very broad conception of federal power. He relied on the notion of implied powers, the necessary and proper clause. Right? These are generally doctrines that give the federal government sweeping authorities. And to this date, Prigg is one of the broadest readings of federal power ever. Even though the Slave Act says nothing, the Slave Clause says nothing about giving Congress power, the court accepted that argument. All right. That wasn't the only argument. Salmon Chase was a young abolitionist lawyer from Cincinnati who would become Chief Justice later in life. Chase argued that no, there's no enumerated power that protects, there's no enumerated power that gives Congress this authority. Chase's argument was rejected. So here we're seeing that the idea of enumerated powers isn't just about constraining law in a conservative direction. At least from the Civil War and the antebellum era, it was the federal power that was harmful to the cause of freedom and fighting against slavery. Now let me bring this to the modern era. We had a decision a few months ago, you may have heard of it, called Dobbs concerning abortion. And we're seeing also parallels to this. Can a state restrict the ability of its citizens to travel to other states to procure abortions? Prigg may soon become a very timely precedent. The next topic I want to talk about involves what's often called judicial supremacy. Judicial supremacy. We often take for granted that the U.S. Supreme Court has the final word on certain matters. Maybe you don't, maybe not in this room, I don't know. But historically, at least, people took that for granted. But this isn't gospel, right? The Constitution says that the Constitution is the supreme law of the land. Not the Supreme Court, not whatever five lawyers say, it's the Constitution. And I think we all can agree at some point the Supreme Court errs. They make mistakes. They do something incorrect. Perhaps one of the most egregious, most erroneous decision ever, everyone might agree with me on this one, is Dred Scott. I think he's nodding, yes. This was a, no pun intended, a dreadful decision as well. The Supreme Court was confronted with a fairly narrow question of law. Diversity of citizenship. What does that mean? A person of Missouri can sue a person of New York in federal court, right? But to avail yourself of this law, you must be a citizen. Was Dred Scott, an emancipated slave, a citizen? The court could have just said, no, Scott was not a citizen because he was not emancipated under state law, therefore there's no diversity jurisdiction, case dismissed. That could have been a very narrow holding. But instead, Chief Justice Taney had other ideas. Taney decided to, or he tried to, resolve the slavery issue by himself in a decision in the Supreme Court. And he had this lengthy, egregious opinion explaining how people of African descent could never be citizens, even if the law of their state granted them citizenship. They can never be federal citizens. They can never have rights like free speech and the right to bear arms. None of that was germane to the actual dispute with Dred Scott and Sanford. But the effect of this ruling is that people of African descent, whether free or enslaved, could never become citizens. Is that the law of the land? Is that the final word? Not everyone agreed with that. An entire movement, the abolitionist movement, rallied around opposing the Dred Scott decision. And there was a young lawyer, you may have heard of him, named Abraham Lincoln, who was an abolitionist lawyer from Illinois. And Lincoln made his national platform on opposing the Dred Scott decision. Now, Lincoln didn't argue that we need to ignore Dred Scott or that we can just sort of flout the decision. Instead, he made a legal argument. Dred Scott was a dispute between Dred Scott and Sanford, two parties in the case. The federal government was not a party to that case. Therefore, the federal government is not bound by that case. What? Did I just say that? Lincoln said you limit the dispute between Dred Scott and Sanford to those two parties, and the effect has no bearing on federal policy. Lincoln rejected the notion of judicial supremacy, that the decisions of the court bind everywhere, everyone immediately, just by virtue of 5 lawyers saying so. Lincoln was elected as president as the Civil War was exploding. And Lincoln made this the policy of the US government. How? His State Department granted passports to freed slaves, expressly saying that you are citizens. His administration granted citizenship to slaves who joined the Union Army and to their families, flouting the Dred Scott decision. The Emancipation Proclamation freed slaves in large portions of the South. Lincoln's policies were consistent with the idea that Dred Scott did not bind the federal government. The idea is the court cannot speak for us all. A lot of you are all nodding saying, yeah, go Abe, right? Go Honest Abe. So now let's talk about another case that creates some tension, which is Cooper against Aaron, 1958. You've all studied Brown v. Board of Education. You know what it said, that separate but equal is no place in public education. And the court later said that there should be desegregation with all deliberate speed. Remember that one? All deliberate speed. Well, it wouldn't be so fast. It wouldn't be speedy or deliberate. Instead, southern states and some northern states as well resisted the Brown decision. It was called a massive resistance. You have the White Citizens Council and other groups saying we need to stop the Supreme Court's oppression, this supremacy. What arguments did they use? They used the arguments that sound a lot like Lincoln. They said, well, Brown v. Board was a case between Topeka, Kansas and a family in Kansas. Those are the only people that are bound. We are not bound by that decision. And it required district court judges in every single city in the United States that were subject to segregation issuing separate orders. So then what happened when the district court issued an injunction against the governor? They would just transfer the schools to private ownership. They would do everything in their power to evade the ruling in Brown with the same logic as the Lincoln argument on judicial supremacy. Which brings us to Cooper against Aaron. The sort of pinnacle of the resistance happened in Little Rock, Arkansas. You had a federal district court judge who ordered integration. You had a state court judge saying, no, integration violates the state constitution, stop integration. So you had these officials of the school bound by dueling orders. You had injunctions against the police department So the government calls out the National Guard, right? It's like a whack-a-mole game. Each successive party that's bound by litigation is then supplanted by somebody else. Eventually, President Eisenhower says enough. Now, Eisenhower didn't really support Brown. He was sort of ambivalent about it, but he didn't like the idea of states subverting federal authority. So Eisenhower sent in the federal troops to escort the Little Rock Nine, these 9 black children, into the building against an angry mob. And in fact, it's very sad. The first day of school they spent in the principal's office for fear they'd be lynched. Right? It took the federal government, the president, sending in armed guards to escort these children to go to school. The decisions of the courts didn't enforce themselves. But then we get to the Supreme Court, right? Cooper v. Aaron arises when the district court actually said, all right, you know what, this is too chaotic, let's postpone the integration for a bit. And the Court of Appeals said, no, do it now. So the Supreme Court says, you must integrate immediately. But they go on this sort of discourse, this other tangent where they said, the decisions of the Supreme Court are the supreme law of the land, right? Our decisions bind you everywhere, even if you're not party to the litigation. So you might think the idea of opposing judicial supremacy is good when Lincoln does it. But when Governor Orval Faubus of Arkansas cites Lincoln, maybe not such a good idea. So these same sort of threads appear over and over again. And now we're seeing, I think, massive resistance to the Supreme Court again. With respect to abortion, people oppose the decision vigorously. I think we'll see it soon, Dean, with affirmative action. We'll see what happens. But I think universities will engage in resistance to try and limit the decision to its most narrow sense possible. You guys have Prop 209. I guess you're already under it, but it will happen soon. Let's talk now about enumerated powers and discrimination. So you're all familiar with the Civil Rights Act of 1964, right? This is a very famous law that prohibits segregation in places of public accommodation. But that law was not enacted until 1964, almost 100 years after the 14th Amendment was ratified. Now, what you may not know is that in 1875, Congress enacts the Civil Rights Act. And that act makes it a crime to exclude a person from a place of public accommodation on the basis of their race. So, Josh, wait a minute, why do we need a 1964 act if they banned segregation in 1875? Well, the Supreme Court did not allow it to go enforced. There was a case called, or actually a series of cases called the Civil Rights cases. These civil rights cases were a series of almost like test cases, if you will, right? Could the federal government restrict the ability of private businesses to segregate? The Supreme Court said no, that the 14th Amendment was not designed to give Congress a sweeping power over private businesses. Why? These businesses were not engaging in what was called state action. State action, right? The 14th Amendment applies to a state, and a business was not a state. Therefore, Congress had no role to prohibit segregation, right? But then there was a lone dissent, right? There was a lone dissent by Justice Harlan, John Marshall Harlan I. Now, you may have heard of Justice Harlan's dissent in Plessy v. Ferguson. This was another dissent that is very famous and should be given more credit than it is. Harlan argued that, yes, Congress could prohibit private segregation. He argued that these tools of exclusion were the badges and incidents of slavery. This was the phrase used, these badges of slavery. Even though the 13th Amendment says neither slavery nor involuntary servitude shall exist, right? What's the difference between slavery and involuntary servitude? They mean the same thing, they're kind of synonymous. Slavery is something more, right? Slavery is more than just involuntary servitude, it extended beyond. And Harlan argued that keeping a person out of a theater, out of a hotel, out of a restaurant, this was a reflection of the state of slavery that existed prior to the Civil War. And that keeping these institutions segregated was perpetuating the notion of slavery. Now, Harlan was the lone dissenter in that case. The vote was 8-1. He was the only one who took that position. So fast forward 100 years, or about 9 years. And Congress is debating the Civil Rights Act. And they have a couple choices, right? How can Congress go about prohibiting segregation? They can do so through the Section 5 of the 14th Amendment, but the Supreme Court said you can't do that. So instead they turned to another provision, which you probably studied, which was the Commerce Clause and the Necessary and Proper Clause. And Congress said, we're going to ban segregation of these businesses through the Commerce Clause, right? So we have a test case now. Harding Atlantic Motel, and another one called Katzenbach against McClung. McClung was the owner of a barbecue joint in Birmingham, Ollie's Barbecue. And so you have a hotel off an interstate in Atlanta. And the court said, well, people traveling through the channels of commerce, oh, that's commerce. Congress can regulate it. It's kind of weird calling people commerce. Then you have the restaurant in Birmingham. Now, the restaurant in Birmingham didn't cater to people out of state. All their customers were locals. What was the connection between this local barbecue joint and interstate commerce? The court says, well, they use ingredients from out of state. Their ovens are made out of state. Their utensils are made from out of state. And, this might make sense to a constitutional lawyer, but to a regular person is, well, that's not interstate commerce. But then you have a dissent by Justice Douglas. And Justice Douglas says, wait a minute. Why are we twisting and turning to try and turn people into commerce, right? To treat a human being as a commercial entity, which is sort of perverse, when we have a provision that says Congress can enforce laws that ban or that deny people equal protection laws. He goes back to Harlan in the civil rights cases. He would have, I think, overruled the civil rights cases. They couldn't quite do that in dissent, but he would have wanted to, and given Congress its federal enforcement power to prohibit segregation, which is a much more natural fit than the Commerce Clause and the Necessary and Proper Clause. But because the Supreme Court rejected in the civil rights cases this argument of federal enforcement power, we now have these expanded, bloated Commerce Clause doctrine. And in case you're curious, the Supreme Court reaffirmed the civil rights cases in the United States against Morrison in the year 2000. Okay? The next case that I would like to talk about is Lochner. How many of you say Lochner? Everyone's going, ooh, you're starting to shiver when I even say the name. Lochner is viewed as this awful case that represents what judges should not do. I'm not so critical, right? And let's explain why. Lochner's come to stand for something more than the actual case was, right? Lochner's come to stand for this way of judges using their own personal preferences to put aside the political process. So who actually was Joseph Lochner? Joseph Lochner was an immigrant baker in upstate New York, in Utica. Okay? He made bread, he made pastries, whatever a bakery does, but he had a very small shop. In the early 1900s, the state of New York enacts the Bake Shop Act. And the Bake Shop Act imposed a number of health restrictions on bakeries. For example, they couldn't keep animals, like a cat or a dog, inside the bakery floor. You had to have certain cleanliness standards, right? You had to have certain standards of health and safety. Those provisions were not controversial. But one provision of the law was. One provision of the law said you couldn't work more than 80 hours a week in a bakery. And we take the sort of laws for granted today with maximum hour laws, but that was very controversial in the 1900s. What was the reason for the law? So you might say, well, people work too many hours in a bakery, they may become tired, and if they're tired, they may not, do their job well, they may, allow sanitary to lapse, right? There are all these sorts of issues that could arise. Let me tell you why the law was probably enacted. Immigrant bakers pose a threat to competition, right? Because think about how you bake bread. You know how to bake bread? It takes a lot of waiting time, right? So first you have to make the dough, you have to wait a couple hours and let it rise, right? And you have to put it in the oven and wait a couple hours so it cooks. There's a lot of downtime. So a lot of these immigrants did is they would just make the dough, they'd sleep, they would put it in the oven, they'd sleep, and there would be a 24-hour cycle, be working around the clock, but a lot of downtime. The larger, more established bakeries opposed this immigrant model because it provided competition. And in large part, the various guilds favored these laws, which would put out of business the immigrant bakers. Because if you were an immigrant baker, you could only work 80 hours a week, you couldn't do enough to keep the ovens hot all day long. So these were laws that you may think, well, they're trying to help the small guy, sure. But it's often the case that regulations are favored by the bigger businesses because they have the ability to comply with them and to enforce them. All right, so what happened in the Lochner case? The Supreme Court, by a 5-4 vote, Justice Rufus Peckham upheld all the other aspects of the Bake Shop Act, like cleanliness and the like, except for the 80-hour rule. And he said the 80-hour rule lacks a sufficient connection to health and safety. You had a dissent from Justice Harlan, who I mentioned earlier, saying that, this is a closer call. There is a right of economic liberty, as you might call it, but we should be more deferential. And, Justice Holmes wrote a solo dissent in Lochner. And Holmes said, no, we need to be restrained. We cannot set aside these laws. It is not our role. It is not our prerogative. But really, what was the Lochner case about? Again, this was a small baker who was trying to challenge a regulation that put him and his family out of business. Now, over the 1910s, the 1920s and 30s, Lochner became this movement. In fact, Teddy Roosevelt started talking about Lochner on the campaign trail. He viewed Lochner as this case of what judges should not do. I think he had appointed Holmes to the bench, so he perhaps was proud of that decision. But Roosevelt made Lochnerism this very bad thing. By the time you get to the 1930s, Lochner was the sort of exemplar of what judges should not do. This was the bad. Judges should not be looking to the due process clause, right? The due process clause, right? To set aside laws that were enacted by the democratic process. Which brings us to the 1930s and President Roosevelt and the New Deal. President Roosevelt comes to office with this agenda, this New Deal, to have progressive federal laws that can help, or at least try to help, bring the United States out of an economic tailspin. The states likewise were enacting various economic laws. So we had laws governing minimum wages, maximum hours, workplace conditions, laws governing protection of unions, you name it. In a very short period of time, sweeping laws were enacted that regulated every facet of the economy. The state laws were subject to challenges under the due process clause. That is, did this regulation of economic activity deprive property owners of their liberty interests under the due process clause? The federal laws were challenged under the Commerce Clause. That is, did Congress have this federal power? But things came to a head in 1937, right? After President Roosevelt's re-election, he announces what was known as a court packing plan. The idea was we have to add seats to the Supreme Court. Why? Well, the justices are old, right? They're slowing down. So for all the justices over the age of 70, we'll add one new one, which would give Roosevelt maybe 4 or 5 new appointments. Now, no one believed him, right? This was a pretext, 100%. The reason why FDR favored this court expansion plan was he didn't like the opinions being written by some of the older, more conservative judges. Politically, there was a non-starter, right? Even his own party, the Democrats in Congress, did not favor the court packing agenda. So the idea fizzled out. But shortly after Roosevelt sort of pulled back the court packing plan, the Supreme Court decides a case called West Coast Hotel v. Parrish. Elsie Parrish was a chambermaid who worked at the hotel in Wenatchee, Washington, the Cascadian Hotel, the West Coast Hotel. It's called Cascadian now. The West Coast Hotel in Wenatchee, Washington. And there was a minimum wage law. And her employer refused to pay her the minimum wage. So she challenged the law. Actually, to be precise, it was actually her husband challenged the law. At the time, she could not bring the lawsuit in her own name. It was actually her husband brought the lawsuit. But so her husband challenged the law on behalf of the wife. Under the Supreme Court's governing precedents, a minimum wage law was unconstitutional. They had struck down a similar law in a case called Atkins versus Children's Hospital from a decade earlier. But in West Coast Hotel, the Supreme Court overrules Atkins v. Children's Hospital and a few other related cases. And the court signals that we are getting out of the business of stopping laws based on the Due Process Clause, stopping economic regulations on the basis of Due Process Clause. Now, it's often said that the votes in West Coast Hotel changed because of the court packing plan. I think there's pretty good evidence it's not true. We have the so-called docket books, as the justices wrote down how they would vote in each case. And the vote in West Coast Hotel was set before Roosevelt's plan was announced. To be precise, the deciding vote was Justice Owen Roberts, no relation to John Roberts, although they both changed their votes apparently. Owen Roberts had previously voted to uphold, he had previously voted to strike, he had voted in the past to keep Atkins in place, that's to allow the court to strike down economic regulations. But what was unique in those older cases is no one asked to overrule Atkins. However, in West Coast Hotel, the court said, we were being asked to overrule Atkins, and we're going to do it. So the fact that Roberts changed his position in the past was not due to the court packing plan, it was due to the litigation posture. But once we get to West Coast Hotel, the sort of Lochner era comes to an abrupt end. A number of the more conservative judges would resign from the court, and ultimately Roosevelt would make 9 appointments to the court. 9. He got them all, right? It's the entire bench, right? Not since Washington have you had that much influence, right? But the Roosevelt judges were sort of the mind of we need to be about judicial restraint. And then you have cases like Caroline Products, the famous footnote 4, where the court said we're going to not set aside the political process unless perhaps certain rights are at issues or the political minorities are at issues. It was a very restrained court. But then the court gets to segregation. And we get to Brown. And they start perhaps deviating a little bit from the restraints of the 30s and 40s. And then we get to the 1960s. Liberation. I'm in Berkeley, right? That's where it all happened. And we have Griswold in Connecticut. And Griswold said, well, the Constitution protects the right of privacy. It's not from the First Amendment, maybe from the Second Amendment, maybe from some penumbras. It was very vague where the right came from. We don't really know. But the court at that point cracked open the New Deal settlement, right? The sort of repudiation of Lochnerism that lasted for about 30 or so years came back and said, well, Lochner's still bad, but we'll protect these sort of personal rights. And Griswold begat Roe, which begat Lawrence, which begat Obergefell. And we go to the present moment, all right? Where is the current court on these issues? Well, the court seems to be trending in the direction of a text and history approach, as the court likes to say. We saw text and history in the Dobbs case of abortion. We saw text and history in the Second Amendment case, Bruin. And we saw text and history with the Establishment Clause in Kennedy v. Bremerton. The court is deviating from much of the precedents from the Berger Court and the Warren Court and using text and history to decide these matters. Now, let me sort of sum up the example. I'll turn over to Erwin in a moment. The Supreme Court story can't be reduced to a few headlines to read today. Its institution's been around for 200 years. And I think to really understand what the court's doing today, you need this full history. There is nothing new under the sun. I mean that sincerely. A lot of the debates we're having today about judicial supremacy, court expansion, right, federal powers, due process, have been had and rehabbed for 100 years. So, you buy my book, maybe, possibly. And if not, take Erwin's class to learn a lot more. Thank you so much for your time, and hope to get some questions from you later.
Josh, thank you so much for coming to Berkeley. I read your book and enjoyed it immensely. And for those who are in con law this semester, we will cover all of the cases that Josh just referred to. If you're in con law this semester, we spent a lot of time today on the Brewing case and talking about the Second Amendment. I very much enjoyed Josh's presentation. I would offer 4 thoughts having listened to it. One is these cases show how much the Supreme Court decisions affect all of us, often most important, the intimate aspects of our lives, how much they matter for society. Think of the case he started with, Prigg versus Pennsylvania, and think of the fugitive enslaved people who are not allowed to remain free because of the Supreme Court's decision, but instead return to their owners. Think about Dred Scott versus Sanford and how it very much helped to precipitate the Civil War. Think about the Civil Rights Act, cases like Katzenbach versus McClung or Heart of Atlanta Motel that opened up travel in the South to African Americans who previously couldn't stay at a hotel or eat in a restaurant. Or think about Dobbs, which Josh mentioned, and the women who are not going to be able to exercise reproductive choice because of the Supreme Court's decision. Second theme that I had identified from Josh's presentation is that the Supreme Court's decisions are very much a product of who's on the court and their values. There's no such thing as a neutral body of constitutional law that's out there to be discovered. The decisions of the Supreme Court are very much about the ideology and the life experience of who's there. You certainly see that in the examples that Josh talked about. Half of the justices who were on the court when Dred Scott was decided were slave owners. I don't know that Dred Scott would have come out the same way. It was a court, in fact, I'm sure it wouldn't have. It was a court of abolitionists. Or take the example of Lochner versus New York. As Josh points out, Lochner is part of an era from the 1890s to 1936 where the Supreme Court struck down 200 federal, state, and local laws safeguarding workers and consumers. It was a product of having a very pro-business, economically conservative court that was committed to a laissez-faire economy. At the same time, they were very conservative morally, and they were willing to uphold moral regulations where they wouldn't uphold economic regulations. I have a different perspective than the one that Josh implied with regard to Lochner. The law in Lochner said that bakers could not work more than 10 hours a day or 60 hours a week. Pardon?
I think I said 80, I'm sorry, I meant 60.
No, it's okay. The result, what we know is that especially at that time, being a baker was a very unhealthy profession. You refer to Justice Harlan's dissenting opinion, where he talks about the tremendous health harms to bakers. Bakers and bakery owners didn't have equal bargaining power. Workers and owners of factories didn't have equal bargaining power. The legislature stepped in to impose maximum hour laws or minimum wage laws precisely to equalize bargaining power. The Lochner court rejected the ability of the government to equalize bargaining power. West Coast Hotel versus Parrish expressly embraces that the government can regulate to equalize bargaining power. What West Coast Hotel versus Parrish recognized was that the market can limit the choice of individuals every bit as much as laws of the state can limit that. And at the same time, when we talk about decisions being the product of who's on the court, the civil rights cases like Katzenbach versus McClung, Heart of Atlanta Motel, were a product of the liberal Warren court who was on the court. And let there be no mistake, Dobbs is the product of Donald Trump having won the 2016 election and picking 3 justices for the court. If Hillary Clinton won in 2016, and if she picked those 3 justices, no one believes that Roe versus Wade would have been overruled. It's all about who's on the court at the time of the decisions. Third theme that I would draw from having listened to Josh today is that originalism can't protect us from bad decisions. We often need non-originalism in order to protect our society. Prigg versus Pennsylvania was an expressly originalist decision. Justice Story's majority opinion said the Constitution wouldn't have been ratified without the Fugitive Slave Clause. Dred Scott should be an embarrassment for originalists. Chief Justice Taney wrote his opinion entirely in originalist terms, and in terms that are quite offensive when you read them. On the other hand, we think about the need for non-originalism. Brown versus Board of Education can't be justified from an originalist perspective. The same Congress that voted to ratify the 14th Amendment also voted to segregate the District of Columbia public schools. There's no indication that Congress in 1868 or the states that ratified the 14th Amendment meant to outlaw segregation. With regard to the Commerce Clause, hard to know what the original intent was. By the way, Douglas concurred. He didn't dissent.
I'm
in this
sorry.
case. Oh, it's minor. But there were cases in the early 20th century during the Locke era that said that Congress, under the Commerce Clause, could regulate people. Caminiti versus United States involved a federal law that's still in the books, very sexist, the Mann Act, that makes it a crime to take women across state lines for immoral purposes. And the Supreme Court upheld that as within the commerce power. I think that Douglas was right. It would be better to use Section 5 of the 14th Amendment. But at the same time, I think that it does fit within the commerce power, because hotels and restaurants that discriminate did have a substantial effect on commerce. They very much limited the ability of people of color to travel in the United States. And the fourth and final thing that I'd identify is, I think the cases that Josh raises, at least some of them, ask us, how much can we expect from the Supreme Court? I raised this question at the beginning of constitutional law. We'll come back to it through the semester. I mean, Cooper versus Aaron, like Brown versus Board of Education, is for me the court at its best, stepping in to protect people where the political process wouldn't. I think Heart of Atlanta Motel, Katzenbach versus McClung, and upholding the Civil Rights Act are this. But what about Dred Scott or Prigg? Should we have expected more from the Supreme Court there? A number of years ago, Charles Ogletree, who was then a professor at Harvard Law School, did a program on whether or not Dred Scott was inevitable. And he got 4 law professors, lawyers to argue. It was me, Akil Amar, Ken Starr, and John Payton. And he got Chief Justice Breyer to be the presiding justice and 10 African-American Court of Appeals judges to be the panel. And my position was we should have expected more from the Supreme Court than Dred Scott. That the Supreme Court could have and should have, by 1857, realized that slavery was a stain on society, and we should have expected them to eliminate it. I don't think we should celebrate Justice Story, given his opinion in Prigg versus Pennsylvania. I think for undoubtedly a brilliant man, he should have found a way to do better than he did. But it does ask us to think about what's realistic to expect from the Supreme Court. So those are at least some thoughts in listening to you.
Thank you. Thank you so much. I'll just a brief rejoinder, 2 points. Irwin just wrote a book on originalism, which I encourage you all to read.
Thank you.
It's true. There's good originalism, and then there's some bad originalism. If you want to see some bad originalism, look at Chief Justice Taney. Some good originalism, look at Justice Curtis's dissent in Dred Scott. I'll give you one example. Taney said when the Constitution was ratified, it was unthinkable that people of African descent could vote and be citizens, and it simply wasn't true. Some states granted the franchise to free blacks. So there are replete errors in Taney's originalism. In fact, it's sort of perverse to say that Taney was originalist is to agree that the Constitution was pro-slavery. This was a very controversial topic. People like Frederick Douglass and Lysander Spooner and others argue that the Constitution was not pro-slavery. At most, maybe it was ambivalent or it was a mixed compromise. It's an issue that people don't always agree on, but there's good and bad slavery. I think also Joseph Story screwed up. It wasn't the best. Read Salmon Chase's arguments. He has a much better originalist account. But I think where Irwin and I do agree, though, is that the product of the court is based on judicial philosophies. And from the beginning, when presidents were appointing judges, philosophy factored into it. And without question, the Dobbs case is a product of Trump winning and putting 3 people on the court. By the timing of fate, Justice Ginsburg's passing in September of 2020, 8 weeks before the election, sealed the deal. Had she retired, I think as Irwin suggested, during the Obama years, Roe would still be on the books, right? So these things do matter. And Justice Breyer retired last year. People are already calling on Justice Sotomayor and Kagan to retire. We'll see what happens there. But there's a huge connection between the law and judicial philosophy. That's all I have. Maybe some questions from students. If you have any?
Yes, thank you both for your insightful
Oh, hi.
remarks. Yes,
That's
I have a
cool.
mic. So if you have a question, please raise your hand and I will give the mic to you.
Hi, my name is Mark, and you mentioned some of the back and forth that always happens after big decisions, and continues there for some time after, between states pushing back against court decisions. Off the top of my head, we could think of states pushing back against people's ability to vote. More recently, a state like California pushing back against the expansion of the Bruin decision. And so while those are very different, I was wondering, what are some themes you see through history of how the legal process deals with that back and forth between the states and the courts on those issues?
Sure, I'll go first, and Erwin's feverishly writing notes. He'll go in a moment. The courts can enforce their own rulings, and if the courts ever go too far ahead of where the people are, there will be some backlash. In fact, Justice Ginsburg was quite famous for criticizing the Roe decision because it went too far too fast. Justice Alito graciously cited that over and over again in the Dobbs case. We saw with desegregation, the Supreme Court said, desegregate with all deliberate speed. It took in some places decades to integrate the schools because the people simply weren't ready for it. I don't think the Supreme Court going too far too fast ever works. Now, in a decision like Bruin, 43 states had, shall issue, that is the right to carry outside the home. And you have big states like, Chicago, Houston, Dallas, Phoenix. So, it's different than what California had, but it's not that radical. Roe overruled the laws in 40 states overnight. In the 70s, the Supreme Court said the death penalty was unconstitutional. That didn't last very long. They sort of pulled back on that. The affirmative action decision, I think, actually might be more sweeping because as it stands now, people in blue states can have access to an abortion. There's not that much of a difficulty, and people with means at least can travel. But if the Supreme Court comes down hard on affirmative action, you'll see in other states, they're going to have to really fight against what they see as infringing on diversity efforts. I think that will be an even bigger push than we've seen post-Dobbs.
I want to disagree with one thing Josh said, and then try to say that you can't look at this in a homogeneous way. There's different contexts. Josh says you can't go too far too fast. Roe versus Wade, by my count, struck down laws in 46 states. There are only 4 states that had legal abortion in 1973. And that was the law for 49 years. It didn't change because the court went too far too fast. It changed because the composition of the Supreme Court changed. I could certainly give other instances where I believe the Supreme Court made major changes. Think of the decisions in the early 1960s that imposed one person, one vote. That required that all legislative districts be about the same size. A dramatic change. And it worked, it was implemented, it mattered. I think we've got to be careful, though, about thinking of pushing back, meaning the same thing in all instances. In some areas, it's the Supreme Court saying this is left to the political process and states can do what they want. And in that instance, the states aren't pushing back. So when the voters of Kansas protect the right to abortion there, or the voters in Michigan do that, or the voters in California do that in November, that to me isn't pushing back. That's the Supreme Court saying, this is left to the political process, do what you will. And those states went in one direction, and West Virginia and Indiana and Oklahoma went in a different direction. There's a whole second category of things where the Supreme Court says that the government can't do something, and then states try to find, well, what can they do consistent with that? So the Supreme Court finds the right to abortion in Roe, and states kept trying ways to regulate abortion consistent with Roe versus Wade. And we talk about so many cases that the Supreme Court decided involving particular kinds of abortion regulations, some being upheld, some being struck down. I don't see that as anything impermissible. Same thing's going on now with regard to the Second Amendment. The Supreme Court in Heller and more recently in Brewer have limited what states can do. So states are trying all sorts of ways consistent with the decision, they hope, to get around it. When the Supreme Court, as everyone expects, overrules the affirmative action cases, I expect colleges and universities will try to come up with ways consistent with it to achieve diversity, finding proxies for race to achieve diversity. And then there's a whole different kind of pushing back, and that's the massive resistance that occurred in the South after Brown versus Board of Education. And that's, to me, in kind different than the other two categories. And there's probably more categories than this. But when you look at what the Southern states did, try to do everything they could to obstruct desegregation, closing public school systems, calling out troops to block the integration of schools, that to me is a very different kind of pushing back.
Hi, I was hoping that you could both comment on any pending cases or cases that might have been argued recently, but opinions haven't been issued that you feel are the most consequential. And if you could just kind of weigh out what the stakes are, I think that would be really interesting.
Sure, I'll give a few examples. We've already talked about the two affirmative action cases that were argued on October 31st, Students for Fair Admission versus University of North Carolina, and Students for Fair Admission versus Harvard College. It's significant that they involve both public schools under the Constitution and private schools under the 1964 Civil Rights Act. We saw here in California the devastating effects in terms of diversity of eliminating affirmative action. If you look at 1995, the year before Prop 209, and 1998, 2 years after, the number of Black and Latinx freshmen at UCLA and at Berkeley fell by half. It took UCLA 19 years to the year 2015 to get back to its 1996 levels of diversity. At this law school, in the classroom where you're sitting, because I don't think this classroom has changed in all these years, in the class that entered the year after 209, there's only one Black student in the 1L class, and that was somebody who'd been admitted previously and deferred. There are ways to achieve diversity without affirmative action, but it takes concerted efforts and a lot of trial and error. And I think we're going to see that nationally. And I'm hoping that other states will learn from the California and the Michigan and the Washington experience. The Association of American Law Schools is going to do a big conference on July 10th for deans and admissions officials about how to achieve diversity without being able to engage in affirmative action. Another case, if you ask me what case on the docket I am most afraid of, it's a case called Moore versus Harper that was argued on December 7th. It involves the so-called independent state legislature theory. North Carolina is basically a purple state. It went for Obama in 2008 and then for the Republican candidates. Trump beat Biden in 2020 by 1.35%. Democrat and Republican voter registration is almost even. The Republican legislature drew election districts to give Republicans control of 10 of 14 seats in the House of Representatives from North Carolina. The North Carolina Supreme Court found that that violated the North Carolina state constitution. They had an independent commission draw districts in a nonpartisan way. Not surprisingly, North Carolina elected 7 Democrats and 7 Republicans in November 2022 to the House. The leaders of the Republican North Carolina legislature sought Supreme Court review and said, Article 1, Section 4 says that the legislature of the state shall set the time, place, and manner of elections. That means that the courts can't overrule what the legislature does. If the Supreme Court accepts that, and I hope they won't, then there'll be no remedy in any court, federal or state, no matter how egregious the partisan gerrymandering. Then I think it's likely that independent districting commissions, like in California, will be unconstitutional because they're not the legislature of the state. It would mean that no matter how extreme the violations of the Constitution, state courts would be powerless to be able to stop what the legislature is doing. And there's further dire implications. There's another provision in the Constitution, it's in Article 2, Section 1, that says the legislature of the state shall allocate the electors of the state. If the court buys the independent state legislature theory, does that mean that a state legislature could give its electors to the candidate that lost the popular vote? Could a Republican legislature in Wisconsin or Georgia or Arizona give the electors in the Electoral College to the Republican candidate, even if the Democrat won the popular vote? And what if that decides the election? I think our democracy could not survive that happening, and that's not hyperbole. One more case, 303 Creative versus Alenis, argued on Monday, December 5th. Lori Smith runs a business in Colorado designing websites. She wants to design websites for weddings, but she says because of her religious beliefs, She won't design websites for same-sex weddings. Colorado has a law that prohibits business establishments from discriminating based on race, sex, religion, sexual orientation. Smith brought a lawsuit in federal court for a declaratory judgment that would violate her First Amendment rights of free speech and free exercise of religion to apply that law to her. The federal district court and the 10th Circuit ruled against her. The 10th Circuit saying there's a compelling government interest in stopping discrimination based on sexual orientation, and that justifies whatever infringement on our First Amendment rights. The Supreme Court granted review. From the oral arguments, I think the Supreme Court's going to rule in favor of Lori Smith. The court's focusing just on the free speech aspect of this. They didn't take cert on the religion question. But once the court says that people can discriminate in the name of free speech or free religion, what's the stopping point? What about the landlord who doesn't want to rent property to an interracial couple because of his religious beliefs? Or the employer says it's against my religious beliefs to have men and women in the same workplace, so I won't hire women. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. The Supreme Court, including in cases like Carter of Atlanta Motel and Katzongas McClung, has said that preventing discrimination is more important than protecting the freedom to discriminate. Once the Supreme Court says, for the first time in decades, that there's a freedom to discriminate, I don't know what the stopping point will be.
Yeah, let me more questions.
Do you want to have other cases? You want?
Those are three I was going to mention. One other fun case that actually you may not care about, and I'll get to you in a second, is actually a case called Norfolk Southern, where you've taken civil procedure ed. Remember personal jurisdiction, right? Pennsylvania has a weird law that says if you do business in the state, you must consent to personal jurisdiction. So you have a tort that happened, I think it was basically in Virginia or Ohio. And the citizens are Virginia, Ohio citizens. They filed suit in Pennsylvania because the trial courts are more favorable. How can you have personal jurisdiction? The Supreme Court may decide for the first time whether a state can require consent for jurisdiction consistent with the due process clause. If this works, the good people in Sacramento will likely file suit. And any business that does business in California will have to consent to personal jurisdiction, and the trial lawyers will be happy. Again, this is not a particularly sexy case. It's not very attractive, but this could be a huge implication for business, which actually the chamber is freaking out over this case. This was a huge case. It was amicus top to bottom. So you had Carter Phillips representing the railroad. You had Ashley Keller representing the tort person, the victim of the tort. So this is a huge case. Just keep an eye on it because this one will be in your SIPRA books next year, I promise.
Okay, thank you, Dean and Professor. I was wondering if you could both comment on Brackeen v. Holland and just what will
Sure.
happen, I guess, in your view after that decision comes down.
Right. So this is a very complicated case involving what's called ICWA, the Indian Child Welfare Act. It's very complicated, and I don't think I can even do justice to it in a few moments. But part of it will affect tribal authority and the power of tribal authority to provide care for their, or not even their own members, but people who might be related to their own members. There's also the Indian Commerce Clause lurking in the background, the power of the federal government to regulate it. There's state sovereignty issues. To what extent can Congress intrude on state domestic law? Usually domestic law is considered an area of the law unto itself. The Fifth Circuit issued a decision in this case that was so fractured and splintered, it makes almost no sense. I don't know what the court's going to do here. Erwin, do you have any predictions?
I agree with all of that. I would just say two things. I agree with everything that Josh just said. One is there is an issue in this and several other cases this term about when state governments have standing to sue. And it's interesting that I can identify at least 4 cases on the docket this term where that comes up, and this is one of them. The other is the Indian Child Welfare Act gives a preference for Native American families when it comes to the adoption of Native American children. It's a response to the tragic history of the government breaking up Native American families and moving Native American children to white families. I think this is going to turn on whether the court perceives being Native American as a racial status or as a political status. If it is seen as a racial status, then the court's going to think of this through the prism of the affirmative action cases and say you can't give preference on the basis of race to Native Americans. But if you see Native Americans as sovereigns and being a part of a tribe is a political status, then it's quite different. The University of California has taken the position that being Native American is a political status, not a racial status. and therefore it's not covered by Prop 209.
That's interesting. I didn't know that.
Yeah, the general counsel, so we can't have scholarships on the basis of race. We have scholarships for Native Americans
Tribal.
because it's on the basis if you're an enrolled tribal member, because it's deemed a political status. My prediction is 4 justices are going to say it's a political status. Gorsuch, Sotomayor, Kagan, and Jackson. Will they get a 5th vote? And I don't know the answer to that question. I don't think you can tell from oral
I have no
argument.
idea. The oral argument in that case was so messy and it was long. By the way, just, the arguments are supposed to be an hour in length. This year they're going 90 minutes, 2 hours.
Oh,
This
really?
It's dreadful.
The oral arguments from the case were 5.5 hours
All day.
in the independent state legislature. And as somebody who's argued many times in the Supreme Court, I have very mixed feelings. On the one hand, as a lawyer, I'd rather have more time to answer questions. On the other hand, there is such a relief when you're up there and the red light comes on.
Yeah, you're over. You're done.
You're done. Then sit down.
I think that concludes our time. Thank you so
Thank
much
you.
to both of you.